I'll present him with a bouquet and flowers and a memento. Thank you. MSMEs are the backbone of India's economy, driving employment, innovation, and economic growth. However, many MSME owners and entrepreneurs face serious challenges when dealing with banks, creditors, and regulators. From loan approvals and restructuring to dispute resolution and legal battles, businesses often find themselves caught in complex processes with legal guidance, leaving them vulnerable to financial stress and unfair practices. At Moneylife Foundation, we strongly believe in equipping individuals with the right knowledge to protect their interests and make informed decisions. This session is designed to help MSME owners and professionals understand the rights, legal safeguards, and the best way to navigate financial institutions and regulatory frameworks. To help us gain clarity on these issues, we are privileged to have with us Advocate Manoj Harit, a seasoned legal expert with decades of experience representing MSMEs in financial and legal matters. He practices at the Bombay High Court and runs a firm that specializes in helping businesses deal with various recovery actions. What makes his expertise truly unique is that before becoming a lawyer, he was an entrepreneur himself and having run a textile unit. Even today, he remains actively engaged in horticulture at Malegaon while practicing law in Mumbai. His deep understanding of banking laws, regulatory disputes, and corporate litigation makes him the perfect guide to help MSMEs navigate financial and legal hurdles effectively. Without further ado, I'll now invite Advocate Harit to please share his valuable insights.
Thank you, Akshay. Thank you, Moneylife. So, we are here to talk about MSMEs and the aspect of legal issues faced by MSMEs. Now, legal issues do not spring up on day one. There is a huge lineup, events, things, small things, big things that happen before an MSME is forced to deal with the legal issues. I'll just take you briefly through those aspects which would also be important for the purpose of this talk, as well as for the purpose of you knowing as to what lies ahead right from day one. So, can we have the first slide? Yeah. I don't need to elaborate anything on this particular slide for the simple reason that these are the definitions, and because we are talking about MSMEs, because MSMEs form the very backbone of the industrial system of our country, although nowadays it is in deep trouble because of various factors, which are some of those factors are in our control and most of them are beyond our control. What I'm going to talk today about are the factors which are in the control of the entrepreneur. Because for the external factors, we can do literally nothing. But there are many factors which are within the control of the entrepreneur. Now, these are the definitions. Why we are having this talk? These are some of the schemes. This is taken up by Moneylife Foundation from one of the Government of India advertisements. The Government of India is focusing, at least that's what the government claims and says, focusing majorly on MSMEs with some of the schemes. This is one of the advertisement given by Government of India from which Moneylife has taken up to show that it actually is a focus area. Today is 7th March. Incidentally, this slide also has from 3rd to 7th March. It's an outreach camp, Pan-India, Mega MSME. Why? Because the MSME sector, although belatedly the government appears to have realized that, okay, we have ignored it, we have hammered it down, we have given it unjustified, unwarranted cuts and hits. But now at least let us focus on my complete good wishes that all these schemes become successful. The entrepreneurs should look for the details of these schemes and then see which of the scheme fits them and their profile and their industry and approach the appropriate the respective government department and try and take benefit of these schemes. Now, after these schemes, another slide to show how focused the Government of India and the state governments are in respect of the MSMEs. They have created some more than 4,500 clusters across India. Clusters for every conceivable activity that can be undertaken by an MSME. Having information of all these clusters is really, really important. Here are an example of some of the clusters in Maharashtra. I'm not taking you through these clusters, but I must tell all of you that having your unit, having your new entrepreneurship enterprise established in a cluster gives you innumerable advantages because an ecosystem is available. You have everything that is related to that particular cluster, that particular industry. Take for example a leather cluster. You'll have similar kind of units. You will have some units which are doing backward integration work, some units which are doing forward integration work, so that you can think of one isolated aspect of that particular industry. Take for a textile cluster. You can have a weaving unit manufacturing and weaving a fabric in a cluster, because you will have the input for weaving ready being made by some other unit in that cluster. And then somebody would buy the fabric from you, dye it, bleach it, and then give it to the next guy. The next guy would stitch some fabrics, clothes, and then market it. So that's the whole concept of the clusters. Now, we come to the gist of our topic today, which is an entrepreneur to start up a business, he would put in all that he has, plus he needs to borrow. He needs to raise money. Unfortunately, an entrepreneur for a greenfield project other than a few VC finances who are available, although they are not still in MSME sectors, they are into all those technology companies. If I want to set up a leather unit or say a fabrication unit, no VC is going to fund me. So an entrepreneur by default will have to approach a financial institution. It could be the state financial institutions. There used to be a lot of state financial institutions which were established especially for this particular purpose, to provide finances to budding entrepreneurs for the MSME sector. Now we really don't have much of a functioning state financial institutions. Now the entrepreneur is necessarily required to go to the public sector bank or the private sector bank or an NBFC or a cooperative bank or a multi-state cooperative bank, entities like these. These are broadly the funders. Of course, SIDBI, you can go to SIDBI, but again, SIDBI is a finance corporation, so it is a lender, and getting through SIDBI is again a task. Whereas an entrepreneur, because he might be into a business, he might be having some working relation with some banker, some lender, so it becomes easier for him. That becomes the first port of call. That's the place where he approaches. It could be the bank. Now there are certain aspects of credit facilities an MSME entrepreneur must be aware while availing the credit facilities. I'll take you through to some of those aspects. The first one, where almost all, I would say almost all MSMEs and entrepreneurs do a mistake, is they do not insist on adequate funding. What happens is, an entrepreneur thinks about and chalks a plan of a project of say 5 crore rupees. He has put in whatever he has, 50 lakh, 75 lakh, 1 crore, 1.25 crore. He goes to a banker for the funding. Now for availing the funding, he has to present a plan to the bank, which is prepared by his financial consultant or a chartered accountant, to show that, okay, this is what my unit is requiring, and it is called a project report. That project report is to be submitted to the bank. The banks and the lenders, I would use the word lender, the lenders have their own mechanism of determining as to what is the maximum permissible bank finance for that particular project. Invariably, their calculation never meets or matches up with the calculation or the requirement as made by the entrepreneur. What happens generally is, the banker would say, okay, all right, look, you are short of 50 lakh rupees. You accept our sanction. You start with the funds which we are giving you, and after say a period of 3 months, 6 months, 9 months, we will review and we will enhance the credit. The chartered accountant or the financial consultant, he also convinces the entrepreneur that yes, look, this is how it is done. Why? Because the ratios are not matching. The bank cannot give you the entire amount of funding because the ratios do not permit the bank, because the norms of the bank do not permit the full financing which you require as of today. An entrepreneur, because of that particular stage, he is in a state of mind that he wants it anyhow. He wants to go ahead with the project. He gets convinced by what is told to him. He gets convinced that all right, the remaining part of the fund, whatever is the inadequate or short funding, that would be made available to him. Or he does his own calculations. He says, okay, I'll do this, I'll borrow from my friend, I'll arrange for the money, and thus starts the inadequate funded project, which finally leads to most of the loan defaults. Second one is, never create a mortgage on your house. Every banker would want you to mortgage your house. That's not required, that's not necessary. For an industrial finance, the Reserve Bank of India norms and the industrial policy of the central government, the union government, none of it mandate more than 50% collateral. And the 50% collateral is, if you are taking 4 crore, I'll continue with the 5 crore project example. If it is a 5 crore rupees project, you have already put in 1 crore of your own money. You're borrowing 4 crore, but you're putting up a project of 5 crore. So that is more than sufficient security for the bank. But the lender, and because at that time you are told by your financial consultant and by the lender that no. Only the project as a security or a collateral would not do. We will require a collateral security. And you say, all right, I have a plot, I have an agricultural land, I'll keep that as security. They say no. Keep your residential house as security. That going forward becomes a weakness with the entrepreneur while dealing with the banks. How? We will see that further. Now comes the third part. You must have heard, you must have read, it's a very beaten down term. Read the documents carefully. Every advertisement, every newspaper, everybody who wants money from you, everyone who wants to sell you something, mutual fund walas, these, that, everyone says read the documents carefully. And that exactly we don't do. Especially an entrepreneur. He never does that. He never reads the documents carefully. Now there is a perception amongst the borrowers and even general people. The perception is, look, the banks are and the lenders, they are respectable and trustworthy organizations. They would not do anything foul. They will not play foul with me. They will not do something which is not as per the Reserve Bank of India guidelines. They will not do something which does not fit within the laws of this land. Unfortunately, that's not true. Sometimes knowingly and a lot of times unknowingly, the bankers do make mistakes purposely, knowingly, unknowingly. And that's why what is important is read the documents carefully. I'll take you through only 2 examples why you should read the documents carefully. The first one is about a sanction letter. Please see. On the right hand side, left hand side is interest free period of 45 days or something. That's written under the promotional schemes and all. On the right hand side, please see. Yeah. Okay. Oh, sorry. Okay. On the right hand side, you will see that per annum at daily rest currently. Now, it's completely illegal. The Reserve Bank of India does not permit any lender to charge interest at daily rest. But this is what? And this is a sanction letter of one of the agricultural related loans. Now, Reserve Bank of India guidelines clearly say that for an agricultural related loan, the rest would be quarterly. Instead of quarterly, like the commercial lending where the rest is monthly, this particular financial institution is saying per annum at daily rest, which is every day morning, every next day morning you're paying interest on interest. Such kind of borrower would never be able to repay this loan. Never in his life. And unfortunately, you write to Reserve Bank of India, you write to anyone, nobody cares. Nobody looks into it. I'll show you one more example from the commercial side. Now please see. This is a loan of 30 crore rupees to a builder and developer given by an NBFC. 30 crore rupees by way of a revolving credit facility. I have redacted the names, of course, I cannot share the names. Please see interest rate. 21% per annum plus other statutory levy, if any. I have a lot to say about 21% per annum, but because the lender and the borrower both have agreed, who are we? Begani Shadi mein Abdullah Diwana. Why should we worry about that? All right. So the next one is where I am worried about. Additional interest. Please see. 30% per annum, that is original 21% per annum plus additional 9% per annum. What is written after that is very important. On overdue amounts in case of non-compliance of the terms of the transaction document and or in case of occurrence of event of default. Now two things I want to show you. One is this is a sanction letter. These kind of sanctions, no entrepreneur, no borrower should ever accept because they say non-compliance of terms of the transaction document. In this particular case, the transaction document is 288 pages. There are all the conditions that they can think of from across the face of the world. There are some conditions, some terms which are not found in India's financial system. They borrowed it from some foreign financial system and added into those documents. And no borrower, no matter how much he wants to comply with it, will be able to ever comply with all the conditions. But that's not what I want to say to you, that read the documents carefully. Read the documents carefully is for the next reason. This is a sanction letter. The same lender, same borrower, while executing the loan agreement, make a slight change. Please see what that change is. This is from the loan document. Yeah. I'll read 2.16.2. In the event of any irregularity in the loan account or any default or non-compliance of the terms and condition, that is transaction document, the applicable interest rate stands revised to 30% per annum, automatically revised interest rate. Then during the period of such irregularity, default or non-compliance, interest will be charged at the revised interest rate on the outstanding amount. There he says on the irregular amount. In the loan agreement, it is changed to the entire outstanding amount. Your loan is 30 crore. In your monthly interest is the monthly interest would be about 12 lakh rupees. If you fail to pay that monthly interest, the 30% penal interest according to the sanction letter would be on 12 lakh rupees. But according to the loan document, it will be applicable on the entire 30 crore 12 lakh rupees. Therefore, read the documents carefully. Now just imagine the difference. You're paying 9% more on a defaulted amount of 12 lakh, and you're paying 9% more on the entire amount of 30 crore 12 lakh. A borrower would never be able to repay these kind of loans. Now this particular borrower, I'll at a particular stage in my a discussion with you, I'll also highlight the aspect as to what are the legal remedies available to this particular borrower and what actually happened with him. And this lender, with all our judiciary, all our judicial systems, all our regulators, regulatory authorities, where does this particular borrower stand today? We'll come to that at the later point of time. Therefore, please read the documents carefully. This is one more a common mistake which I have encountered from a lot of my clients or a lot of my friends, or even I myself have committed this particular mistake, which is 5 crore rupees project. I'll go on with the 5 crore rupee project. 5 crore rupee project, 1 crore is required for land and building, 2.5 crore are required for machineries, and rest of 1.5 crore is required for working capital funding and all. The entrepreneur has put in his money, his factory is shade, he has purchased the land, he has got it converted, he has set up a factory, his land and building is complete, and his bank proposal is going on at that time. What he does is he gives some advance and books the machinery in the hope that the sanction is about to come next month, next to next month, and the machinery wala is going to take 3 months, 6 months to provide me with the machinery. As of today, not less than 20 cases are there with me, either presently or I have dealt with it, that an entrepreneur and his factory is lying there locked out under the bank's auction, because after initially when the machinery was ready, the bank loan did not come, the disbursement did not happen, and when the disbursement happened, the machinery supplier put up further conditions that I am holding it on to for 6 months, 3 months, 1 year, whatever may be the reason. The technology has become obsolete. A lot of reasons. The machinery never comes in the plant. The unit never starts. The entrepreneur loses his factory, his land, of course his house, because he has already mortgaged it. And that commercial activity never gets even started. It may appear to be a very, very common and general point, but I am stressing it here because I have encountered lots of units which have not produced a single kg or a single unit of a product, and that entire money is lying locked up, and the entrepreneur completely entangled and defeated in the legal process. To highlight, there are many. I can give you an example of somebody, a young entrepreneur in onion belt of Maharashtra, decided to set up an onion dehydration plant. Same thing. There is a machinery. The plant never started, not even 1 kg of onion ever got dehydrated over there. I can give you an example of a industrial unit, a forging unit, having an investment of 180 crore just on the outskirts of Mumbai. 3 bankers came together and funded that unit. The bankers extended a loan of 80 crore rupees, all 3 together. The entrepreneur put in about 120 crore. Germany, France, Italy, across the world there are machineries all brand new. We see there are some forging companies that are doing so well in the Indian stock market. Their shares are booming like anything. Now here is a plant which has 75,000 metric tons per annum capacity. All the machinery is lying ready. But due to this particular mismatch, when the machineries came, the repayment of the term loan had started. He could not do that because he had already invested his entire money, 120 crore of it, in the unit. Not other than the initial trial production, not even one railway wheel has been manufactured in that particular forging unit. After fighting a legal battle for almost 3 years trying to save that particular factory, the gentleman, the entrepreneur, has finally, just in the last week, lost the possession of that factory. Now the factory for the past 3 years is locked. Earlier there were efforts going on from the entrepreneur to start the factory. Now there are efforts going on by the bankers and lenders to auction it off. Just imagine 300 crore rupees worth of investment lying there only because of this one mistake of placing your machinery orders before having your money tied up. That's a mismatch which a entrepreneur must avoid. This looks very general, this looks very small, but the results and the consequences are so bad, and you have nowhere and no forum where you can get any relief in between this phase. The reliefs, of course, we will talk when we are talking about legal things, we will talk about that, but unfortunately the reliefs are when you have thrown in the towel, when your assets are taken over, when your assets are put on sale, and when you have lost your will to even save your assets or save your unit or revive your unit. That's when you start to see some hope after the legal process. So this never matches. Therefore, be very firm about at least all these 4 points to avoid the avoidable things that can go wrong. Now, when an entrepreneur starts the unit, in the beginning, everything is hunky-dory. These are the good times. During the good times, there are certain things which an entrepreneur must do. I list a very few of them. Of course, every entrepreneur will have his own priority, will have things to do which are very important for his own or her own perspective. I've noted down a very few, which is get the complete set of documents from your lender. Almost nobody does it. Almost everyone by law, by default, must do it. You have executed the document, the lender has given you the money, you have put in the money, your factory has started, you can walk into the office of the bank or the lender and ask him, Baba, give me my entire set of documents. Then go through the documents, keep the documents, that's the further stage. But getting the entire set of documents, because what happens is when things go wrong, The bankers are the people who refuse to share even a copy of a sanction letter. Things get very bad. Therefore, during the good times, have the entire set. You should know what are the documents you have executed. You should know what are the properties which you have mortgaged. You should know whether the bank has a valid and legal charge over the properties or not. You should know all these things. And after going through the documents, if you find the mistakes, get those mistakes rectified and the documents amended then and there. Things are good. Banker is happy with you. He has given you money. At that time, he will consider. He'll do whatever is required. Get it done then and there. Like if the earlier example, I'll say ABC Limited was the borrower, the 30 crore example I gave. So if ABC Limited, the firm, had looked into the documents, got a set of documents and looked into the documents carefully and found out that the terms of sanction vary substantially from the terms of the loan contract, he would have got it amended. He could have got it amended. He would have, he would have been saved from all that he has to suffer. It was a very small thing to do. But nobody looks at those documents. Nobody asks for the documents from the bank. That becomes a problem. When the times are good, please pay your employees, your suppliers, everyone well, everyone on time. Because when the times are bad, those are the people who are going to help you. When the times are good, please, all your repayment obligations to your lenders, try and meet those repayment obligations. Because all these people, whenever the times are not good, those people would extend you extra hand. That's what makes a difference between sustainable a period and unsustainable period during the bad times. Now this is one thing which every entrepreneur by default must do. Please create a Dasra for the lean period. Actually, a Dasra is a financial concept. Every lender, whenever the money is to be lent for project finance, they mandatorily make and create a Dasra, usually for a period of 6 months, installment plus interest. That amount is kept aside. If the business is unable to pay back during a month or 2 months, the amount lying in the Dasra is utilized so that the loans are not defaulted. You create your own Dasra. You see what are your requirements. You create a Dasra for yourself, for your industry, at least of 6 months. Not only limited to the loan. If your banker, your lender has already created a Dasra to take care of the defaults in repayment and the interest payment, you create a Dasra for your other needs of the business. Now this is also very important part. Every month, whenever the banker debits your account with the interest, before making the payment, do the calculation, ask your chartered accountant to do the calculation, and only then make the payment. Make that a habit. Nobody usually does it. People don't look at it. बैंक ने किया तो ठीक ही किया होगा. बैंक वाला क्यों ज़्यादा करेगा? It's not that the banker would do it purposely. I think in one of my interactions on a public forum, I have given an example. There was a MSME unit which was sanctioned a credit limit by a public sector undertaking bank, PSU bank, and right from day one, when the disbursement was done, right from day one, the bank charged him penal interest the penal interest was 3%. There was no default. I mean, just कल तो पैसा दिया है, आज तुम penal interest charge कर रहे हो. And he realized it when the loan became non-performing and he approached a lawyer. How did that happen? Because the manager of that particular branch failed to establish a DP limit on his loan account. So the computer system, because no DP limit was established, for the computer all the amount that was disbursed was treated as overdrawn amount. So right from day one, a penal interest got charged. And then what happens is, once you're paid, and then it becomes very difficult to convince the bankers, because you don't know what has happened in the system. But when you come up with your own calculation that, look, the interest should have been 100 rupees, you have charged 118 rupees, please give me back the credit of 18 rupees, the banker would never give you. In this case, okay, it was maybe that MSME owner was lucky, the banker gave the credit back, and the credit was 38 lakh. That's a huge amount. And the loan was not even very big, around 2 crore or 2.5, I don't recollect correctly. So the bottom line is, do not make the payment of interest unless you have verified it on your own or from a professional. Now, this is a very important part. A lot of entrepreneurs who approach us, we find that they have nothing, almost nothing in written communication with the bank or the lender. They say, मैं तो गया था बैंक में, बात हो गई, मैनेजर ने बोला ये कर लो, मैंने कहा ये कर दो, ऐसा हुआ वैसा हुआ, but there is no communication. Believe you me, only those entrepreneurs, those MSME owners are able to avail legal help and legal assistance who have kept a clear track record of communication with the bank. This is very important. You find that your banker has charged you more interest, the first thing you should do is write a letter. You find that one of your customer is not going to buy the same quantity next month, and you are going to have to carry extra stocks which will require further infusion of funds. The first thing, after talking to that particular customer and doing your own housekeeping, you should write a mail to the bank that, look, this is what I'm expecting. I'll be requiring 10%, 5%, 2% more money, or at least I would require a deferment of repayment, at least for a month or 2 months. You almost always you will get it, because these are the powers given to the branch manager level officer. But if you don't write, you go to the manager, you speak to him, whether he gives you or not gives you, later, at a later point in time, you have absolute no recourse. So please have a communication. This is the practical approach, why I am stressing on this. Now comes the legal aspect. You are an MSME. There are various Reserve Bank of India guidelines which govern the financing to NBFC. Those guidelines also include certain notifications and guidelines whereby the lenders are given instructions for rehabilitation of MSMEs. Now those rehabilitation instructions, just on 1st of August 2024, the Honorable Supreme Court passed a judgment wherein the Supreme Court said that each and every RBI guideline notification has a binding effect on the banks and the lenders. Interestingly, it was a case where a bunch of petitions were heard together. Some of the petitioners, at the time when the recovery action was initiated by the bank, had not written to the bank that, look, I am an MSME and I am entitled to the benefits of this and this RBI guideline, or I am entitled to MSME Act benefits and Reserve Bank of India. You don't need to quote the particular notification. No. But I am an MSME. I am entitled to all the rehabilitation guidelines. So you please don't go ahead without giving me the opportunity of that particular rehabilitation of my unit. In that judgment, Supreme Court granted relief to those who had returned to the bank, denied the reliefs to those who had not returned to the bank. In a single judgment. Because the Supreme Court held that, okay, when the lender gave you a notice or classified your account as NPA for the first time, did you go to the lender and inform him that you are an MSME? You are entitled to the RBI guidelines? If you have not, today after your factory is taken over, sold off, you can't come and say that, oh, I am an MSME and the bank did not do it. Of course, there is an space for improvement in that reasoning of the Supreme Court as well, because the very first page of a loan application form and the very first document an MSME gives to the bank is the registration. Now it's called Udyam registration. Earlier it used to be called a registration with the DIC, District Industry Center. So it's not that a banker is not aware. The Supreme Court could have said, hey, you have given the funding. You should know whether it is MSME or not. But all right, that is what has happened. At least something good has happened, because the similar matters, the same arguments were rejected by our own High Court. When the same borrowers had gone to the High Court said, oh no, nothing doing. These are, if the lender has not followed or not complied with these guidelines, that doesn't disentitle the lender from recovery measures, which is throwing you out of your property, selling the property and recovering the money, which was completely wrong, but that's how it is. Therefore, writing to the bank should be the very first thing. Write down everything. कुछ नहीं होता है, कौन सा लेटर कब जाकर आपके या आपके लॉयर के काम आएगा, you don't know on that day. There will be question and answer. Yeah. Next. Yes. So we are on to the negative part of it. There would be tough times. The first thing I'll say is smell the coffee. Don't remain in your entrepreneurial role when you hit the tough times. Be more a pragmatic, because entrepreneur by nature is a wishful thinker. So he would, dream of kal ye ho jayega, parson wo ho jayega, which never happens. So please smell the coffee. Then be truthful to yourself. Analyze the situation and assess it with a negative bias. The negative bias must be underlined, because we all, because even I am an entrepreneur prior to shifting to law. So we entrepreneurs always are in a positive overdrive mode. We don't want to come to face with reality. We are seeing that, okay, the business this month or for the last 3 months hasn't made any money. The market conditions are such that the business is not going to make money for another 3 months, 6 months, or a considerable period of time. Maybe the product is not accepted. Maybe your machinery has gone wrong. Maybe a lot of things have happened. The tests have changed. The demand in the market has changed. At at that time, do an assessment which is more realistic than whatever you had thought while initiating the project. Now, this particular stage, what happens is, normally, if this stage comes, say, 25 years after being in business, it becomes very difficult for the entrepreneur. He thinks that, boss, मैं 25 साल से business कर रहा हूँ. I'm making good money. I've done whatever I've done. I've purchased a big bungalow, made a house, bought a farmhouse and all that stuff. From this business, I know the business. So he is wishful even till that time. Therefore, what is the very first step is, please start doing the assessment and do it with a negative bias. Again, the same point. Please write to the banker and seek solutions from the banker. The very first time you default on your interest payment and the banker calls you, sir, interest baki hai, your first reaction is, 2 दिन में भर दूंगा. Your second reaction is, sir, the payment was going to come, it has not come, it will come in the next week. Third week of the month, your reaction to the banker is, sir, what I'll do is, next month I'll make the payment together for both the months. You never tell him, I haven't earned money, or my liquidity or my working capital cycle has undergone a change. There is a shortage of funds in the business that do not allow me to make that payment. Please find a solution. They have a whole lot of banking tools at their hands. They can help you with, they can grant you a temporary overdraft. They can reassess your requirement of the funds. They can give you an incremental loan. They can ask you, they can say that, all right, we'll give you a FITL, no problem. Don't pay interest for 6 months. For the 6 months interest will give you FITL, funded interest, a term loan. So there are things, but you should not be like, okay, अगले महीने भर रहा हूँ, 2 दिन में दे रहा हूँ. That shouldn't be the approach. Now this is the step where you started, whenever at a stage when you have started finding difficulty in repayment obligations, the first thing you should do is, please put money aside for your emergency, personal emergency. Usually what happens is, entrepreneur, they do the opposite. They try and bring in funds from other sources. They would borrow some money on personal loan. They would borrow some money from friends and relatives and put into the business, assuming that, all right, this is for a temporary period. It is never for a temporary period unless you have corrected the fundamentals of the business. Therefore, keep some money aside for emergency fund. It is related to C. Don't borrow for business or industry from friends and family. Do not. If you don't pay the electricity bill, your energy supply is going to be disconnected tomorrow morning, and today night you are calling up your best friend, your relative, your mama, your tau, anyone, and you are asking for that money. Please don't do it. There are other ways of avoiding that disconnection. That time you can avoid it by various means, but once you have taken that money, without looking at or doing the assessment with a negative bias, you will find that your electricity has got disconnected after a few months and you are unable to repay the money from whom you had taken, because you have not looked at the structural inefficiencies or difficulties that have arisen in the business. This is, I mean, normal, but a lot of people don't do it. It is like go to the mattresses, do it on a war footing, cut down on all your extra expenditure. I would say both business as well as personal. मर्सिडीज गाड़ी लिया हुआ था तो बेच दो, कोई प्रॉब्लम नहीं है, छोटा वाला ले लो. इफ यू हैड टेकन अ बिग बंगलो, no problem, sell it, raise that money, use that money, rather than going to a banker and taking up a top-up loan. You have a plot of land, sell the plot of land, raise the money, use it in the business rather than going for further borrowing. Now, these tough times, they have a very stickiness about them. Sometimes they do linger longer than we think they would. So, very elementary. Please don't let your children's education suffer because of your financial difficulties. I don't need to even speak more about it. This is important. Don't permit your CA to doctor your books. He will, or your financial advisor would tell you that, okay, look, you're unable to pay the interest. There is a shortage of funding in your business, but the enhancement of the loan would come only if you show the profits in the books. He will doctor your books. There are very simple ways of doctoring the books. 2-3 ways are there. One, he'll create sundry daters which are not there. Bogus bills bana ke. Of course, nowadays it has become difficult because of GST and e-way bill. It has become a little bit difficult, but still people are doing it. Or show increased stock levels, the stock which is not there, the daters which are not there, and inflate and show profits to maintain the DSCR ratio, debt service coverage ratio, which is sort of a holy cow for the bankers. Unless it is above 1.31, no banker would sanction you the loan. So to maintain those things, the chartered accountant is the first person who would advise you to, change your books, doctor your books. Please do not allow him to doctor the books. This thing has never ended well. It has not ended well even for Satyam Computers. It can't end well for anyone else. So stop there. Ask him, no Baba, I am not earning money from the business. I'll look into my business, my assessment, and then I'll take a decision. This is what I was talking about. Revisit your assumptions, your calculations, targets. Assess the situation to decide whether the business industry needs to be saved or continued. Now, for entrepreneurs, this becomes very difficult. It becomes unthinkable. Just like a man would be willing to sell his residential house in case of financial difficulty, but the woman of the house would not be. She would be like distraught completely. What are you talking about? You want to sell the house. You can't do that. Similarly, an entrepreneur never ever thinks about quitting, even if the business is not making money. That is absolutely a wrong thing to do. Assess the things. Businesses are there. You put in the money. You started the business. It has gone right for 15 years, 20 years. Now it's going wrong. Assess it. If you're not making money, if the potential is not there, stop it. What's so great about it? Collect whatever is the money. Think of starting of something else, something new. This is also important. It's not that I am a lawyer, so I'm telling you to do it. But this is a stage where you must keep a sizable fund aside for litigation. Now, litigation fund is not only about lawyers' fees. It is also about the court fees, which are, I'm sorry to say, very heavy for financial litigation. I mean, if you want to file a simple appeal against a bank's surface action, you'll have to pay ₹1 lakh as court fee. Those fees are heavy. And the most important part, money for litigation, funds for litigation includes funds that are required to meet statutory requirements. Now, what are the statutory requirements? Supposing the bank has initiated some action under the SARFAESI Act, you want to challenge it, you have gone to the DRT, you have paid some amount to the lawyer, you have paid ₹1 lakh as a court fees. After doing everything, the gentleman sitting in the chair at DRT, the judge whom you call, it's called a presiding officer, he'll say, all right, to your lawyer, not to you, he'll say to your lawyer, all right, Mr. Lawyer, you have said 10 different things. You have shown us, or you say that there are 10 different violations done by the lender in the recovery process. Therefore, the recovery process is required to be stopped. All right, we will look into it, but ask your client to show a bona fide if you want us to grant you some kind of a stay order. Now, the bona fide varies from a person to person. It could be from 10% if a gentleman is sitting in the chair. It could be as high as 50% if some total bank-minded person is sitting in the chair. It could be anything between that. And that's the precise moment when you have no money. Look, here is the situation. The banker has done everything wrong. You've gone to the authority that is set up by the law to see that the banker does no wrong. But that authority says, Baba, to see me if the banker has done wrong or not, you have to deposit so much money. It's not there in the statute, but it's there in the practice. If you have no money, you lose your asset. Second is statutory. Supposing that particular gentleman said, okay, I have heard you. I don't think there is merit in your case. You have to go to the appellate forum. At the appellate forum, the statute demands you to deposit 50%. From where are you going to bring that money? Similarly, under 101, if it is a cooperative bank, it takes recovery certificate from a deputy registrar of cooperative societies under section 101 of that particular act. That recovery certificate, that entire procedure, the gentlemen who are sitting and manning those posts across Maharashtra, they neither understand banking, they neither understand financing, they neither understand entrepreneurship, they don't understand industry, they understand nothing. What they understand is bank has applied, I am duty bound to give them a certificate. Without even looking at the justification of it, nothing. So that gentleman has issued a recovery certificate. Now you want some legal recourse, the statute mandates 50% deposit. From where are you going to bring that particular 50% deposit? So that particular part is what is envisaged in the KIF funds for litigation part of it. Because unless you have the funds for all these purposes, of course you can't plan for everything. But if you are aware that, okay, these are the things that you are required to deal with, then probably you would keep it aside. So we have come to a stage where your loan account is either classified as NPA or is about to be classified as NPA. Almost everyone consults the financial guys over here, the chartered accountants over here. Please don't consult them. Consult a lawyer. Don't make that mistake of consulting the financial guys. They would make you go on doing those same mistakes which we just discussed, which would take you further down the road. The second part is initial notices are always ignored by almost all the borrowers, especially the MSME borrowers. First notice comes, they go to the banker, they talk to the banker tells them, okay, you do this, pay this much, they say, okay, give me some more time. They talk on a regular basis, they talk on a daily basis. What they don't do is read the notice carefully, take it to the lawyer, discuss with the lawyer, and reply to the notice carefully. That becomes a handicap going forward. Now this part we had briefly touched upon. There are various banking tools available. There are norms of Reserve Bank of India, there are notifications, then there are certain provisions even in your sanction terms whereby you can get this. In fact, this is something which every MSME must do. If you have done your assessments like we talked about in the earlier phase, if you have assessed your business, if you have done a dispassionate assessment of your business, then you can deal with that through early resolution. If your banker wants, all right, whatever you want to sell the property, take the money, I have these 2 properties, sell it, reduce the loan. So those resolutions would always help. You don't have to get into litigations if you are able to resolve it at that stage by using of all the banking tools that are available to the bankers plus the Reserve Bank of India guidelines that are available. Again, at this stage, look for the exit options, which unfortunately we don't do. Not many. Every entrepreneur wants to cling on to his asset, his business, till he is literally picked up and thrown out by the lenders. They don't want to. But now you have a lot of options. You can look at section 10 of the IBC, you have that exit option. You have pre-packaged insolvency for MSME. So those options are available if it is a corporate entity. If you are not a corporate entity, if you are a proprietorship business or a partnership firm business, still you have the exit options. You can talk to the banker. You can say that, all right, whatever is my money, my contribution, I can take that money, sell the business, I'll help you sell the business. That's the best thing to do. If the business is not making money and if it is unlikely to make money. If you are not exiting, the first thing that you should do is devise a legal strategy. Again, your lawyer would come into picture. Please consult your lawyer. At this stage, once again, revisit what will be the requirement of funds in that legal strategy. At the first stage, if it is 101, how much would be required? If it is section 84 of the multi-state cooperative bank, and if an arbitrator has passed an award, and then you want to challenge that award, then what would be the requirement of funds for you to stand before the court? Everything has to be devised at this particular stage, because till this stage there are some funds available to you. There are some assets. There are friends and relatives who are still ready and willing to provide you with some liquidity for some period of time. The mistakes that are made and which turn out to be very costly is, at this stage, raising the funds and using the funds for the same thing which you were doing, which is repaying the bank, not adequately, but inadequately, which is there are dues supposing of say 50 lakh rupees, you're paying 5 lakh rupees. Don't do that. It's not going to help you anyway. Unless you pay that 50 lakh totally, your loan account is not going to be marked as standard once again. The recovery actions are not going to stop. You have to go through the entire legal gamut once again. So, at this stage, make sufficient quantum, again reassessment of the funds that would be required. It's critical, it's required, it's practical, and people don't do this. Now this is the most important part. Stop paying the lender. Keep the overflow, if any, from the business aside and use it for OTS. When I say stop paying the lender, I'm not saying don't repay your installments or your monthly interest. I am saying if you don't have the entire amount for repayment, if you don't have amount sufficient to keep you out of the NPA tag, stop paying. If you have sufficient funds, like we said earlier, that make regular payments, because those were the good times. You were able to pay. But if you are not able to pay the entire amount, please don't pay a part amount, because it's not going to help you in any manner. Rather, whatever money you can generate, if you're still in the business, if your business is still running, if your industry is still running, if there is money, there is overflow, please keep it aside. Keep it aside, because it will be required at various stages. If you want to go for a legal recourse, the money will be required. If you are sitting with the banker for a OTS, the money would be required. So this money is going to be the difference between whether you survive or not. I've seen examples of people who keep on paying lakhs and crores of rupees for years together, but have no money for the legal defenses or wherever statutory requirements arise, without stopping the legal action. What happens usually is, your account is on the verge of NPA or it has gone beyond NPA. The banker is taking some action under one of the recovery laws, and you want to avoid that action. The banker says, all right, I'll wait for 15 days. What you do is you deposit 5 lakh, you deposit 10 lakh, you deposit 1 crore, you deposit 5 crore. I'll wait for some day. You pay that money, that particular period gets over. Once again he starts the action. This time you have no money. Now we are on to the final part, which is the legal system. Now usually these are the laws which are used by banks and financial institutions for recovery of their dues. SARFAESI Act, RDB Act, and now the IBC. Now I'll I'll take you to the example of 30 crore loan. That sanction letter was of the year 2017, which we saw. The sanction letter was a different, and the terms in the agreement, loan agreement, were changed. Please see this letter. Yes. Now this is a response received from Reserve Bank of India by this particular borrower. Okay. Based on the information, these are exactly the points which I had shown you in the sanction letter and the loan agreement. Please see. I have redacted the names, of course. Allegation in the complaint, please see. In the sanction letter dated so and so, contained in additional interest clause, which reads 30% per annum on overdue amount in case of non-compliance of the terms of the transaction document or in case of occurrence of default. However, contrary to this, the revolving credit facility agreement dated so and so changed the term of additional interest by setting out at clause 2.16.2, which we read, of the revolving credit facility agreement, that in the event of default and any irregularity in the loan account or any default or non-compliance of the terms and condition of the transaction document, the applicable interest rate stands revised to 30% per annum automatically. Then, during the period of irregularity, default or non-compliance, interest will be charged at revised interest rate on the outstanding amount. Sanction letter says the default amount. They change the term in the agreement contract to outstanding amount. So the difference, 12 lakh was overdue, 30% should have been charged on 12 lakh, but it is charged on 30 crore 12 lakh. Just imagine the difference. Now what RBI says is, on the other column, this is Reserve Bank of India. It is observed that the sanction letter issued to the borrower states additional interest to be at 30%, original 21 plus additional 9 on the overdue amount. Look, they have done it in bold. In case of non-compliance of terms of transaction document. However, the loan agreement states the following. Yeah, take it down. They have quoted the entire. The compliance of terms and conditions, revised rate. They have quoted it once again. Now come downwards. This is what RBI says. As such, the loan agreement clause differs from the condition in the sanction letter, which stipulates charging additional interest to be at 30% on the overdue amounts in case of non-compliance of terms of transaction document and or in case of occurrence of event of default. It is our considered opinion that charging penal interest on the entire outstanding amount is not a fair practice on the part of the company. This is what Reserve Bank of India has said. Please calm down. Second part is, we have the borrower had made a complaint that capitalization of interest. On the right side is Reserve Bank's response. It is observed from the statement of account that the interest, including additional interest and charges in the loan account, are getting capitalized, which is not considered to be in accordance with master direction, non-banking financial company so and so, because it is an NBFC which has sanctioned the loan. So this is in non-compliance. Now the Reserve Bank would be filing an affidavit before the Honorable High Court of Bombay in the petition so and so, so and so, so and so. The point here is, in 2017, the gentleman borrows 30 crore rupees from one of the NBFCs. This is the clause that the NBFC has put in. A 288-page document is executed, in which hundreds and hundreds of terms and conditions are given. They allege some violation of the condition. For the first month, immediately after sanction in the fourth month, about 7.5 lakh remained unpaid interest. They charged interest on the entire loan and 7.5 lakh at 30%. This gentleman never looked at what they are charging. Within a period of 1 year, by December 2018, he ended up paying 4.5 crore as interest on a disbursed amount of 15 crore. The NBFC did not disburse the full amount of 30 crore. So on a disbursed amount of 15 crore, he ended up paying 4 crore as interest, because this was the kind of interest that was being charged, and then he lost because he could not pay 30%. Can you pay 30%? Even if you are a smuggler, gold smuggler, you can't. Forget about a legitimate businessman. You can't do that. So this gentleman, December 2018, that NBFC classified his account as NPA. Now, the painful part of this entire case is, against that 30 crore loan, this particular developer, he was developing a large residential housing township project on the outskirts of Mumbai. He has his own 28 acres of land, ownership land. So it's not a fly-by-night operator. The land itself is valued in excess of 100 crore rupees. He already had borrowed money from 3 different banks, totaling 14 crore rupees. He had requirement of 15 crore more for the project. This NBFC said, all right, we sanction you 30 crore, we will repay 15 crores to the other banks, and 15 crore will give you for the development. They repaid the other banks, executed the mortgage documents, not only of the project land and the project, but also his office, at measuring 10,000 square feet, valued at 40 crore rupees. And they started doing this. With 140 crore rupees as mortgage, they did not sanction the remaining 15 crore. That's only part of the story. They started recovering 30% interest from him. The gentleman lost the battle. The very first time when his lawyers went to the debt recovery tribunal, the debt recovery tribunal said, all right, pay 10 crore rupees. He said, where do I have the money? My property and my assets are 140 crore. They are claiming the defaulted amount, the very first notice of demand which was sent by the lender was of 18.5 crore. They said, it's only 18 crore. Let him release my project property. He has 40 crore worth of office with him. I'll sell some of the flats which are ready. I'll pay him, I'll pay you, I'll pay everyone. They said, no, you have to pay 10 crore. The gentleman couldn't bring 10 crore. We are in 2020. Then, to challenge that order, the gentleman went to the High Court. The High Court said, no. We don't look at it. Go to the appellate forum. He went to the appellate forum. Again, the appellate forum said, hey, you'll have to deposit 50%. If the gentleman had money, he would not have gone to that NBFC with these kind of terms in the first place. But what happens? We are entrepreneurs, are wishful thinkers. He thought, all right, a few of my buildings are 95% complete. I'll take this high cost funds immediately. I'll finish them off. Good revenue would come in. I'll close this. So it's a temporary arrangement for 6 months, 8 months. It's 8 years. Not a brick has been laid in that particular project. The project is still stalled. When he lost his office property, worth 40 crore, the lender has already auctioned the property and purchased itself in the auction for 18 crore rupees. And now the lender is claiming 54 crore more. Because with 30%, it can be 500 crore also. If he waits for another 2-3 years, it will be 500 crores. And the lender has disbursed only 15 crore. So that's where he stands. And now because he has lost everything and he has approached the High Court once again, the High Court has directed Reserve Bank of India to look into it. Then for the first time, I mean, this particular, whatever is written by the Reserve Bank of India, was it difficult for the person who is appointed specifically to deal with these matters at the DRTs to look at this? It was not. After all, he is a retired judge. He could have looked into it. This is common sense. You and me would say that, hey, in your sanction letter, a term is different and your loan agreement is completely different. Even we can say that. But unfortunately, the judicial system that we are having fails to look at this. The gentleman has lost everything. The project is still stuck. And now he has some ray of hope because the High Court has thought to go into the matter. Now, if at this stage, if the High Court would have said, no, again, we are not going to look into it, you go to the appellate forum, the appellate forum would have said, what the appellate forum would have said today? It would have said, look, today they are saying 54 crore. So 50% is 27 crore. If you deposit 27 crore, we'll look into the issue. The stakes are completely staked on one side and nobody is there to look into it. Therefore, the earlier portion of my conversation with you, why it is important not to reach to that stage. And even if you reach to the stage of NPA, you should be there to at least be able to defend yourself. Then there are various, I've just given it for the sake of information, that if it is a cooperative bank, believe you me, you are completely in a mess. You have absolutely nowhere to go. They have such drastic powers that they can do anything. I mean, if you're a borrower and if they've obtained a 101 recovery certificate under section 101 of the Cooperative Societies Act, they can take out money from your wife's account. Even if she is not involved in the business, they can take out money from your father-in-law's account as well. Even if it is illegal, there is no check on them, because if you go to the appellate authority, mandatorily you have to deposit 50%. If you go to the High Court, the gentleman sitting in the High Court will say, why should we look into it when you have the authority over there? You go there. It's really, really bad if it is a cooperative bank from which you have taken loan and you have defaulted. Then there are multi-state cooperative banks which obtain awards under arbitration under section 84 of that particular act, where one lawyer is appointed as a bank's arbitrator. He sits in that bank and conducts arbitration, which is completely contrary to the very scope and spirit of the Arbitration Act, and completely contrary to the judgments of the Supreme Court and the High Courts. But that goes on. Again, if there is an award, you have to go and challenge that award. For challenging the award under section 34, 50% deposit. You have no money. You have no remedy. Similarly, they, in addition to RDB and SURFACE Act, they have those powers under that Arbitration Act. And God help you if you have taken money from an NBFC. They'll take, under Arbitration Act, they'll get an award from their stooge arbitrator. That arbitrator will give them an award of whatever amount they want. Like in this particular case, this lender has initiated action under SURFACE. If he had taken a arbitration award, he could have got an arbitration award of 100 crore at 30%, compounding every month. This is insane, completely insane. And you have nothing. And, you know, I mean, this is only the unscary part of having borrowed from NBFC. What is the scary part? The scary part is, you are an entrepreneur based in Maharashtra, say in Nasik district, you borrowed from an NBFC. That NBFC has an office in Nasik. It has initiated the SURFACE proceeding. It has taken over your factory or your residential house. It has done. At the same time, what they will do is, they will initiate an arbitration at Chennai or say Gurgaon. At the same time, they'll initiate a criminal complaint against you, most probably in one of the courts in Kolkata. Kolkata magistrate courts are fantastic. Anybody can walk in, anybody can get any kind of orders. They are simply fantastic. So these NBFCs, they file a criminal complaint against you alleging cheating and criminal breach of trust. And the magistrates routinely issue warrants against you. You are in a small village near Nasik, trying to set up an agro industry, and you are suddenly facing 3 different recovery proceedings for the same loan. One in Chennai, where some arbitrator is sitting and he is issuing you notices. One is SURFACE, he has already taken over your assets. And the third is in Kolkata of a criminal court. And you have no money. What would you do? Unfortunately, there is no control over all these activities, despite this being brought to the notice of the courts repeatedly. Despite this being brought to the notice of the regulators repeatedly. They do it. I mean, yes, I'll go back to the 30 crore loan. It is an NBFC, right? What that NBFC has done, you know, in addition to taking over the office, selling the 40 crore office for 18 crore to itself, having a total charge over that asset, that 26-acre project next to Mumbai, it has filed a 138 check bouncing case in a court at Jaipur. How much amount? 30 crore. Security checks were taken. In one of the check, they have written 30 crore, deposited in Jaipur. The check got bounced. And now the check bouncing case is at Jaipur court. Now imagine what would this particular gentleman do. Now, because that NBFC and this is a secured loan, they have not taken up the way of filing IPC offenses, cheating and forgery and criminal court. Why other NBFCs do it? Because those loans are unsecured. They know that we have no security for recovery of those loans. So what they do is they use or they abuse the criminal justice system and try to, you know, issue a warrant against you so that you would go to them and pay them money. This is what is happening. Now if you are a corporate entity, a private limited company, and if you come within the scope of IBC, this is one topic I wanted to talk about with you, because you're being an MSME entrepreneurs, you should be very much aware about a new thing which is called NESL, which is information utility. Now, for initiating or for putting you and your entity into insolvency, the law requires only two things. The first thing is there should be a default. The law does not even require that the default should be in terms of the Reserve Bank of India guidelines. There should be a default. You were supposed to pay interest on 2nd of March, you have not paid. 7th of March, lender can issue you a notice, come to the insolvency court. And for that, what is the evidence the lender has to show is a report filed with NESL. That's an information utility established under the IBC code. What the banker or the lender do is they routinely send reports to NESL. NESL, the functioning at NESL is, NESL would redirect a mail to you saying that, look, XYZ lender has filed a report with us saying that X amount is due and payable and defaulted. Most of the people ignore these emails because they think, okay, this is something routine. There was a loan, I have defaulted. There is my account, they have classified as NPA. So they don't respond to that. In fact, there is no effective mechanism, even if you want to respond and take objection to whatever the bank has said. In my chambers, in my office, I had to establish a special desk to deal with this. It's such a menace. Every MSME borrower who's undergoing some kind of a default or not even a default gets an NESL mail, and there's something very peculiar about these NESL emails. These emails hit your inbox from about 12:30 into the night till say 5:30 in the morning. I don't know why. They are sending either from some other time zone. Nobody knows what it is. And you have no means of dealing with it. Because if you want to raise a dispute that, okay, the lender has reported to you that my so-and-so loan, so-and-so amount is in default, but I have to say this, it is not a default. They just ignore that. And the IBC code, the insolvency code, it only accepts NESL report as an evidence, and you are put to insolvency. So this particular aspect, it needs to be talked about more. It needs to be written about more, that what you are doing, what is the mechanism. In fact, my office has spent hours and hours on this NESL website without finding a proper A to Z explainer as to how it works. So it's completely opaque, and yet it is the ultimate clinching evidence for you to be put to insolvency. Therefore, this particular aspect I just wanted to bring to your information. Otherwise, this doesn't fit into this recovery mechanisms that we are talking about. I think we already have covered almost everything. And on the closing notes, yeah, of course, only the questions. We have half an hour for questions. And these are 2-3 quotes. I'll end a conversation with. About half of what separates successful entrepreneurs from others is pure perseverance. Now, with this in our context, in our country, in our judicial system, we must say that it is alongside pure perseverance, your legal strategy would only save you. The second one is by Churchill, success is not final, failure is not fatal. It is the courage to continue that counts, and the courage to continue would come from whatever we have discussed. Without that, you will not have the courage to continue. The last one is, an entrepreneur tends to bite off a little more than he can chew, hoping he'll quickly learn how to chew it. In fact, what happens is, the system ends up chewing him. Let us be aware of it. Thank you.